follow up just a couple of the points that Mr Cole-Hamilton put to you, and then perhaps ask you something else briefly. But I just want to be clear about the version of events, particularly in relation to the meeting on the 29th of March that Mr Cole-Hamilton has referred to. You've set out your position. You say in your written evidence that, and I quote, quoting from your written evidence about the First Minister's version of events. In fact, you're referring to the meeting here, 2nd of April, that the First Minister's claim is wholly false. Now, Nicola Sturgeon was somebody who you worked with very closely over a long period of time. She was your deputy when you were First Minister and succeeded you as First Minister and leader of the SNP. She has said this week, and you will have seen her public statements on the matter, that the claims you're making are untrue, that you have no evidence to support them. In effect, she is denouncing you as a liar and a fantasist. Are you?
Well, what I would say is, given some of the things that have been said about me this week, I don't think you have to add more. There's plenty have been said. The key thing is the evidence. Now, I've already expressed my, and I assume your frustration, that there's some evidence in this is not available to you. But there is no doubt, and it is absolutely certain, that the meeting on the 29th of March in the Scottish Parliament was pre-arranged for the express purpose of Nicola being briefed in the situation with regard to me and complaints, and the meeting on the 2nd of April arose from the meeting, or the final arrangements for it at least, arose from the meeting of the 29th of March. Otherwise, how on earth would I have known to turn up on the 2nd of April? There's no other way the invitation could be gathered. As to why the meeting of the 29th of March was for a substantial period of time, if we remember, effectively written out of history, and I know that some people say, well, what difference does 4 days make? The difference is, of course, if the meeting of the 29th of March is admitted, and indeed the subject matter is admitted, then it makes it very difficult to argue that the meeting of the 2nd of April was on party business as opposed to government business. And all I would say is that that meeting was, in Nicola's terms, forgotten about, but she says she was reminded of it in late January 2019 or early February 2019 in evidence to the committee. If that were the case, then under the Ministerial Code, the correct thing to do would have been to correct the record as timorously as possible, as opposed to waiting 18 months till Sky News broadcast it, as is what actually happened. I'm here under my oath, and I'm giving you the explanation under my oath. That is what happened from my belief. The one thing I would add, and be quite clear about this, that many of the attacks on Nicola in regard to this were about how she was trying to intervene in my favour or whatever. I think there was nothing, and I've said so in my evidence, would have been improper with the intervention I was asking her to make. I mean, I'm well aware of what the Ministerial Code says. I was hoping that she would report to the Permanent Secretary what I'd said, as the Ministerial Code would indicate, because I could not believe that arbitration, or rather, I beg your pardon, I could not believe that mediation would not be properly part of the policy, and that might be a route forward. So I don't share the view that it would have been improper for Nicola to intervene. On the contrary, if a First Minister hears a substantive danger that their government might be drifting into illegality, or that something significant has been left out of a policy, then my view is that is a perfectly proper intervention to make.
Thank you. But can I press you on this point? Because it is of fundamental importance to the issue of whether the Ministerial Code was broken by the First Minister or not. Because she has one version of events, and you have a directly contrary version of events, and she has asked you to produce the evidence. Now, you've said to us you have no doubt that your version of events is correct, but where is the evidence? Who can corroborate your version of events?
Well, I'm not the only one who knew about the the meeting of
who else did?
The 29th of March. It was known about certainly by Duncan Hamilton. It was known about by Kevin Pringle, I believe. And Mr Aberdeen didn't just tell me. I mean, obviously, Mr Hamilton went with us in the 2nd of April, so he knew about the meeting, the fact it had been arranged. So, in terms of exact evidence, the people who turned up at the meeting knew. So, that's corroboration. But in terms of the breach of ministerial code, I would have thought either explanation breaches the ministerial code, because either the meeting on the 29th of March wasn't forgotten about and Parliament was deliberately misled, or alternatively, it was forgotten about and Parliament wasn't informed when she was reminded of it. Now, my submission of the ministerial code says these are, to me, clear breaches of the ministerial code. What happens as a result is not for me. It's for this committee, it's for Mr James Hamilton, it's for others. All I can do is come here and tell you the truth, the whole truth and nothing but the truth, with the frustration, of course, that we all know there is evidence in terms of March 2018, which this committee is prohibited from hearing.
We can, of course, ask Mr Hamilton and Mr Pringle and Mr Aberdeen their version of events, and we may well pursue that. Can I just ask Convener a couple more questions?
Well, as I understood it, you had Mr Aberdeen's version of events in evidence.
Yes, we did. Perhaps I should move on. Convener, you allege in your evidence you've given us, the written evidence, that there is a conspiracy. You don't use the term conspiracy, but you say the evidence supports a deliberate, prolonged, malicious and concerted effort amongst a range of individuals within the Scottish Government and the SNP to damage my reputation, even to the extent of having me imprisoned. And you name, as part of that conspiracy, Peter Murrell, Ian McCann, Sue Riddick and Liz Lloyd. Why would these people conspire against you?
I believe the motivation for furnishing complaints to the police was initially to defeat the judicial review by having it postponed. I think it came to be believed that among some people that the loss of the judicial review, the loss of a court case would be cataclysmic, not just for Leslie Evans, not just for senior officials in the Scottish Government and special advisors, but would be cataclysmic for Nicola Sturgeon herself. And I think, unfortunately, people came to the belief that the police process would somehow assist in, firstly, not losing the judicial review, and thereafter making sure that the loss of the judicial review was swept away in the inevitable publicity of the criminal trial. And if I'd been convicted of any offence in the criminal trial, that would have been the case. Now, and you asked for evidence. Well, in the document I provided to you, in this committee, making the point about the investigative function, Barbara Allison was asked, would it be proper for the Scottish Government to be contacting people, where you describe it as contact or a fishing expedition or whatever, after the police investigation started. And Miss Allison quite rightly said, no, that would be totally improper. Once the police investigation starts, it's a matter for the police. But I've provided you with an email which shows that was happening. And the name at the bottom of that is Barbara Allison. And incidentally, I don't believe that Barbara Allison was a witting part of a malicious plan. I think, I know she was given that information by a special advisor to write unsolicited. A day later, Ms Riddick writes, and I'll false you provided with a letter from the SNP. The person concerned had never been an SNP member. We have a statement from that person, which was given to us for the purposes of my defence. You have the evidence put in by Anne Harvey. And the significance of the evidence of Anne Harvey is twofold. One, that the email she's provided is contemporary. This is a senior official in the SNP Whip's office at Westminster, a lawyer, an officer of the court, who's asked for names, refuses to provide them, because she says, in terms of her professional responsibilities, she's not going to participate in a witch hunt. This is not something she's describing now after the event. This is something she was describing in late August 2018. These things were going on after the police investigation started. In terms of what's in the public domain, then can I point out that in the criminal trial, my counsel read out a message from a complainant refusing to go to a meeting with a senior official because she was beginning to feel pressurised rather than supported. In Sky Television, I've seen an account of a text message of the importance of getting another complainant back in the game from Miss Riddick. I've seen reported and in the public domain a text message which says that if the police can't find the evidence, if you felt like telling them what they need, and I'll get it for them. Of course, again at the trial, a text message was read out saying, I have a plan by which we can remain anonymous. Now, these are things, material, which are in the public domain. They're also material which, as I mentioned earlier, that were said before they came into the public domain did not exist, or their bona fides were questions, which, of course, was the first response to the pressurising the police and all fronts, issue for more fronts to fight on. That was the first response. It can't possibly be true, but they are true. The messages are real. These messages are in the public domain. The evidence from Anne Harvey and of the emails which I provided you with is before this committee. There is much more evidence that I would dearly love to provide to this committee if I wasn't under an injunction in terms of Section 162 that I'm not allowed to provide to a parliamentary committee evidence which was disclosed to me as part of the criminal proceedings. And like in all things, I've abided by the legal advice and I must follow that stricture. Even though, as I noted earlier, as First Minister who introduced Section 162, it was never designed for that purpose. It was designed to stop witness statements being used by drug dealers or whatever to pressurise witnesses. It was designed to stop witness statements being discovered in skips across Scotland. It was part of Lord Coulsfield's report of 2007 about the handling of information. It was never, ever designed to prevent information coming to a committee of this Parliament. And its use in that fashion by the Crown Office is beyond belief and totally and utterly disgraceful.
Just two more brief questions, Convener.
Yes, could I ask, please, Mr Salmond, to not go back to the criminal trial, but to stick to the remit of this committee, please? I understand that you think a lot of these things are peripheral, and I let you answer that question in full, because it's obviously important to you and important to members of this committee. But if we could just bear in mind from now on that we should be sticking within remit. Thank you.
Of course, I'll follow your advice, Convener. I'll follow your orders in terms of the position. Just to say, I mean, the evidence coming to this committee is relevant to this committee. The origins of the evidence are maybe out of scope, but the evidence, if it's relevant to this committee, is relevant. That's the point I'm making, and not.
Yes, Mr. Salmond.
I mean, clearly and obviously, you're correct. The committee's remit is not to rerun the criminal trial or to question the verdict of a jury.
Mr. Salmond, I understand what you're saying, but we also have a policy of taking evidence, which is that the evidence comes in and we decide our publication policy, and that's what we do. So, to talk beyond some of the evidence that we have published can become problematic in terms of our remit. As I said, I was content to let you finish answering that question because it was important to you to get that on record, and it's important to committee members to hear that. I just want to give a warning as to where we go from here.
And then I'll follow your guidance.
Thank you.
Thank you, Convener. Just to go back to my previous question, Mr Salmond, you name in your evidence 4 senior figures within the SNP, including the Chief Executive, who of course is married to the First Minister, and the First Minister's Chief of Staff. Do you believe the First Minister herself played any role in this?
Well, as I've said, Mr Fraser, everything I've said in the evidence that I've submitted to you can be backed up by documentary evidence. So every statement I make, and therefore, since I don't have documentary evidence which suggests that the First Minister has text messages or any other piece of information which involve the First Minister, then I haven't made that accusation. That is because I decided, quite properly, I think, only to make statements that could be backed up by documentary evidence. Can I also say that you mentioned earlier, you said, look, you've never mentioned the word conspiracy. That's for the same reason. It's the easiest thing in the world, and it's been done over the last few days, to say something is a conspiracy theory. The reason I've described this in the way I've done as a malicious scheme or plan or campaign over a prolonged period of time involving the people I've named is precisely because there is documentary evidence which substantiates that. And that's not a theory, it's not a point that can't be established. It is a point that can be established from the documentary evidence. So it's more than just terminology and people's ability to dismiss it. What it is saying what can be verified by documentary evidence. And the only question is how much documentary evidence this committee is allowed to see.
Thank you. Convener, my final question. Mr Salmond, you conclude your written evidence to us of the 17th of February by saying this. The real cost of the Scottish people runs into many millions of pounds, and yet no one in this entire process has uttered the simple words which are necessary on occasions to renew and refresh democratic institutions. I resign. Who should resign?
I think the people responsible for the disaster of the judicial review, I think in terms of Scottish Government, the Crown Office, and in terms of the overall approach, the people who are responsible should resign. The people I've named, as I have the evidence for their behaviour, they should be all considering their positions. Well, as I said in January, I mean, the Permanent Secretary, and I think I say it in my evidence, I mean, to my knowledge, Cabinet Ministers thought she should have resigned on January the 8th, 2019. I can't think many people wouldn't have thought that would have been an appropriate thing to do. Yes, she should have considered her position then, and no doubt she can wait the findings of this inquiry. But and if you're asking my opinion, yes, she should.
Lord Advocate?
I think the Lord Advocate should be considering his position for this and a range of other issues. The issue here is that it's an argument as to whether there's an institutional failure. Many people whose opinions might be close to yours, much closer to yours than mine, have been using this argument to say, the institutions, there's something wrong with them. Scotland is almost a failed state. That's not a view I take. I take the view that the institutions fundamentally are sound, but there has to be some form of political responsibility. You know, institutions have to be refreshed from time to time, and one of the things in public policy is when an issue like this arises, of the extent it arises, that people have to take the consequences. If they don't take the consequences, then the institution itself comes under question. The Scottish Government, in terms of the Administration and Civil Service, needs new leadership. So does the Crown Office. And in terms of the people I name, because I have the documentary evidence to establish what they were involved in, then they should be facing the consequences as well. But in terms of the institutions of Scotland, I think they're absolutely sound, and what it needs is public accountability and facing up to the extent of what has been demonstrated by this extraordinary affair.
If the First Minister has broken the ministerial code, should she resign?
Not for me. I believe the First Minister has broken the ministerial code, but that is a finding that can be discussed, at least by this committee, by Mr James Hamilton. It's not the case that every minister who breaks the ministerial code resigns. I mean, your own party would have an example of that relatively recently. It depends on what is found and the degree by which the ministerial code has been broken. I've got no doubt that Nicola has broken the ministerial code, but it's not for me to suggest what the consequences should be. It's for the people who are judging that, including this committee.
Okay, thank you, Commissioner.
Okay, thank you. Stuart McMillan.
Thank you. Mr Salmond, earlier on you spoke about the discussion that you had with Nicola Sturgeon at her home. And you indicated also that at some point afterwards that Nicola Sturgeon had seemed to have kind of changed her opinion. Can you remember what was actually said at the meeting in terms of what you said to Nicola Sturgeon and what she said to you to give you an indication that she was looking to assist or help?
No doubt the people at the meeting that Mr Aberdeen and Mr Hamilton and they were there, and certainly Mr Hamilton was there when Nicola said that, and she said it in the private meeting to me as well, that she was anxious to assist. But of course, it's not. I don't have to remember it. It's in the WhatsApp messages that you have as a committee. That when I'm surprised by Nicola's response, and I say to her, look, that's not mine. I was being, because obviously I was looking for Nicola's friendship and assistance quite properly. When I say in the message you have before you of the 3rd of June 2018, my recollection of our Monday the 2nd of April meeting was rather different. You wanted to assist, but then decide against the intervention to help resolve the position amicably. Now is different, and that's when we go on to the judicial review. I believed it was a substantial change, as this indicates, in Nicola's position, and I was extremely disappointed. However, I thought there were other possibilities. And obviously we discussed arbitration, and that came later in the discussion. So that was the purpose. But I was extremely disappointed because I thought that at that stage that mediation was an entirely proper thing to suggest, and I thought that Nicola could entirely properly support it for the reasons I've already given. And I simply don't have any time for the idea that it's impossible for First Ministers in terms of the ministerial code to make proper interventions. I mean, the first thing you should do if you get contacted on an issue of government policy is you should contact the civil service, tell them, in this case the Permanent Secretary, and my assumption is not only was I suggesting Nicola should do it, but that was the right thing for Nicola to do. She obviously took a different opinion, but she changed her mind.
Well, thank you for that, but can you remember exactly what was said at the meeting that gave you the indication that Nicola Sturgeon would have intervened as you had requested?
She wanted to assist. She said, I want to assist. There was a discussion about how she could do it. So the discussion wasn't whether she wanted to help, it was about what were the circumstances which would enable her to do it. And she wanted, as the discussion with the Permanent Secretary, to come to her or to find an occasion by which they could introduce it. I found this rather puzzling because it's not the relationship that I had with my Permanent Secretaries. But it wasn't a discussion about whether she was going to help in the 2nd of April. It was how she could best do it. That was the discussion. That's why I was so disappointed in the message I've just read out to you.
Okay, thank you. I've got one more question. It's in a different area. Convener?
No, just say.
Okay, thank you. Certainly, earlier on today, and also in your evidence, discussed about a number of employees and associates, and certainly in your evidence you seem to consider instances of people reaching out to employees and associates to offer support on the subject of sexual harassment as evidence of a fishing exercise. Do you think that it's actually perfectly reasonable for political employers, whether it's the SNP or the Labour Party or Lib Dems or Conservatives or Greens, do you not think it's actually imperative upon the political parties to actually reach out to their current staff members and former staff members? Certainly they would have that duty of care to them, and bearing in mind also kind of what was going on at the time with society. And do you not think that it was the right thing certainly for the SNP to do to engage with their staff?
Yes, I do, but that is not what I'm suggesting, Mr McMillan. I made the point that the police investigation started, if I remember right, on the 25th of August and was publicly announced. At the point a police investigation starts, they are the investigatory authority. I'm not talking about reaching out to people. And Peter Murdo, in his evidence, gave not the impression, I think he gave it to the committee, the email that went out from Nicola Sturgeon to all party members towards late August 2018. What he didn't give this committee was the email that went out from Susan Ruddock, not to all party members, but to selected members of staff and former members of staff. I could produce for this committee many members of staff who didn't receive this email. It didn't go to people who were known to be close to me or worked in my office. Now, you'd think if you had a duty of care, these are exactly the people you'd be sending an email to. But the primary point is this. This is taking place after the police investigation has started. And secondly, the response from Anne Harvey, as I say, a solicitor, officer of the court, to it, she had no misunderstanding or no appreciation that it was anything other than what she described, her words, as a witch hunt. And she described it at that time. There's nothing more important than the understanding that once the police are doing their job, they should be left to get on with it. They shouldn't be pressurised. They don't need anybody else doing the investigation. They are the competent lawful authority for doing it. Unfortunately, as these emails substantiate, there were people who didn't believe that it should be left like that. Now, you don't need my word for this, because before this committee, when asked, Barbara Allison was asked, would it be proper for the Scottish Government to be doing that after the police investigation started? And she said no. The problem is that they were. And the email you have before you demonstrates that they were. I also know that the former member of staff that she's talking about in that email happened to be a special advisor. I also know that special advisor was given the details, which in itself is a question, of the person concerned by a significant person in the Scottish National Party. That should not be happening, Mr McMillan. That is totally out of order. But can I tell you that the information I would like to bring to this committee goes way, way beyond that?